She illegally obtained a protective order. We don't have to get into semantics of all that. I wasn't even in the country. That's been thrown out in every hearing. So I don't want to keep having to go through the process of having that thrown out, because that was quashed less than a month, I believe, after she filed it.
The whole truth and nothing but the truth.
Yes.
Yeah.
All right, you may both lower your hands. Ms. Sweet, you may proceed.
Thank you, Your Honor. We are here on the state's motion to modify the the previous child support order. If I may give the court a brief background before I begin.
Yes, sir. Yes, ma'am.
Thank you, Your Honor. There was a divorce decree that was signed March 7th, 2024. In that order, child support was set to over $800. And then the state had filed its motion to modify child support 3 months later in June of 2024. A month following that is on file Mr. Brooks' motion to modify the support as well. And then, Your Honor, this court had signed the first temporary order on September 11th of 2024, and then signed a further temporary order December 12th of 2024. In those temporary orders, the first one was support based on a little over $2,100 of income. And then in the December 2024 order, support was based on a minimum wage. We're here today. The state is asking that this case be reset for May 29th of 2025 to receive information requested in the state's petition filed June 17th of 2024. That still has not been received by the state. And then I believe Mr. Brooks is requesting that we either do a final, and if not, then that this case be referred to the district court, considering his pleadings filed after the state's.
Okay.
In addition to that, if I may speak, Your Honor.
You may.
Okay, so the reason for my petition is based on Texas guidelines. If they do not have material evidence of a change in my income equating to $100 more or less, you guys cannot continue to bring me to court in perpetuity. The state has not presented that in now 3 hearings. Moreover, the state, I believe, has purposely tried to harm me by, for instance, when I made my initial petition to the court, which was done literally the first Monday after I lost my job. The courtroom coordinator did not add my case to the docket, sent it to the Attorney General. Attorney General then filed their own case, because otherwise they had no evidence. Why would they have started a case for nothing? Beyond that, once that motion was filed, the information was not added to any of the preceding documents, despite being stamped and sealed and approved to be added. So at this point, there's no reason, there's been no material evidence or fact that would warrant this continuing in perpetuity.
What's your response, Ms. Sweet?
Your Honor, first, the state has no control over the court clerks as far as the filing that may or may not have been done in April of 2024. Secondly, there's a temporary order in place that's basing support on minimum wage now, so there's no harm to Mr. Brooks putting this back until May. And third, he's trying to benefit from not providing the state with information required to look to see whether or not it qualifies for a modification and whether modification is appropriate. And fourth, as I spoke to Mr. Brooks, he's not interested in the choices program, and the court is doing these temporary orders and resetting the case in order to see whether or not Mr. Brooks has found any employment, to see where he is at in his employment status. And so, Your Honor, that is why the state is requesting that this case be pushed back again until May of 29th of this year.
Mr. Brooks, have you provided the state with any of the documents that they've requested?
They had the information. So if it was in June of 24.
Mr. Brooks, that's not what I asked you. That's not what I asked you. I didn't ask you what they had. I asked you what you provided. Did you provide them the documents that they requested?
There were no documents to provide in June of 2024. If I lost my job in 2024, they would have had the income that was there, which was what I was already on child support for. If it was June of 2024, there's nothing else to provide after I was terminated. I provided my unemployment insurance, but when I had my unemployment income, I provided that of my own volition. So that was the only information that was available.
They asked for a lot more than just salary information. They asked for income tax information. There are other things that they requested. What I'm asking you is, did you provide that information?
There has not been any request for that. If you're saying in June of 2024,
Mr. Brooks, it is in the pleading. What they request is in the pleading. It's not a separate request. It is all in the pleading.
I know we're talking about June of 2024, correct? Because that was the only pleading. Other than that, it's just been temporary resets, correct?
That's correct.
Again, in June of 2024, the income that was provided would have been that. The tax documents they had, that was in my submission from what my income was previously, because that's what I needed to do to prove that there has been material evidence showing that there has been a deviation in what I was making to what I was currently making. Like, that's what I'm saying. So it went from, this is the income I was making, this is what the previous order was based on. This is no longer current because I've been terminated. This is the current income that I have. Anytime I've procured employment or lost employment, I provided that. There's no benefit for me to not do so.
Okay. Ms. Sweet, were the documents provided that you requested in your petition?
We don't have any of those documents, Your Honor. And I believe what Mr. Brooks is saying is that per the terms of the divorce in March, that's when the documentation was provided. The state wasn't an official party, although we did sign off on the divorce decree. And I do not see where any of that information was provided, or whether or not there was a trial that may have been provided to Ms. Brooks or her attorney at that time. But I do not see that we had any of those documents. Not to mention, if this had happened and the order was signed in March, then the income tax documents for the 2023 year may or may not have been even done at that stage. So not sure whether or not they were provided, but I do not see that they were provided pursuant to our new pleading in June of 2024.
Okay.
In the previous hearing,
what'd you say, Mr. Brooks?
In the previous hearing with Justin, when the previous hearing with Justin Dale, that was the information that he provided relevant to the case. So they have to have it.
Mr. Brooks, I mean, I don't know what they have and what they don't have, sir. I can just go based on what you guys have told me. I'm going to reset this to May 29th, Ms. Sweet.
Yes, Sharon.
Is that what you guys are asking? I'm going to reset this to May 29th, 2025. I would expect all parties to give the documents that the states requested to the state, or come up with a reason why those documents shouldn't be given to them. Okay?
My thing is without material fact, because they can't continue to reset the case. This is now 4 times that we're continuing to reset this case, which is that's not because they don't have any evidence substantiating a reset. And again, we have a private order, so I don't understand why we're entitled to a court in the
my
first place.
ruling. This case is reset to May 29th, 2025.
Well, I moved that my case is heard in the district court.
8:30 a.m. And if you are objecting to their request for discovery, there's a formal way to do that.
Well, I want my case heard in the district court, not here. This is kangaroo court, and it's like.
Well, you can call it what you'd like, sir. And I'm not referring this case to district because there's no reason to refer it. There are no
if we have a private order
circumstances, there are no extenuating circumstances that would justify referring this to district court. So
the case initiated in district court. Why
it doesn't matter where it initiated. The attorney general is a part of the case now. That's why it's in 4D. It doesn't have anything to do with where it's initiated, sir.
I do understand that, but the attorney general has always been a part of it. If we have a private order I have a right to have it heard in district court, so I'll file my own motion. That's fine.
You do not have a right to have it heard in district court. And if you wanted it heard in district court, you would have had to have it referred to district court before now. Okay?
Which was in the motions that I filed that your coordinator did not put on the docket or accept. So that's fine.
Okay. I can't tell you that that did happen or that didn't happen, because as far as I know, the attorney general's filing was first, and that's why it was put on this docket.
So let me ask you, so if they don't have any evidence, right, that settled the change, why would the attorney general just randomly file a modification? That's asinine. It doesn't make sense. They wouldn't just randomly file it. So they filed a modification to lower it. We know that's never the case.
You're arguing a point that is mute at this point because I've already reset this case. That's something you can argue when we come back, sir.
But you're not going to give me a chance to argue. We're going to keep this in perpetuity. violating all the
So
guidelines.
we're not
because
going to keep
there's-
anything in perpetuity. I'm not going to
this
keep
is
resetting
four
this in
times. This is now four
perpetuity.
times with no new evidence.
Well, I don't think it's unreasonable to reset this
It
to
is
May
unreasonable.
29th. I might think it's unreasonable to reset it after then, but I don't think it's unreasonable to reset it this time because the documents have not been provided. Just provide the documents, Mr. Brooks. That's all you
What
have to do.
documents? That's what I'm saying. If I didn't work
They
in
will
2024,
tell
what
you- okay.
documents are there to provide?
Mr. Brooks, the Attorney General will tell you what documents they're requesting. Do you want to go back in a breakout room with him, Ms. Sweet, to
No, I
tell
don't want to
you
speak to
what
them no more.
documents you need?
I'm done with this entire process. I don't want to speak to them anymore. You're asking
Okay.
for documents that do not exist. It was the
Okay.
same thing when she came asking for check stubs. I'm not working. What check stubs are we going to provide?
Mr. Brooks, if there are no
can't leave the court
documents,
with
you
the
need to
report.
turn in something in writing that says there are no documents. If there are no present or past income tax returns, no documents showing any income, no rental property, anything that they ask for in that discovery request, sir, just provide it or say I don't have it in a written form. That's all you have to do.
So in my initial answer, because they didn't, the way they
Mr.
did the
Brooks,
search
I'm
warrant-
not going to keep talking to you about what you did before, okay?
but I'm saying the stuff you're asking for, I've already provided.
this case
It's already
is
been provided. That's what I'm
reset.
saying.
It's reset to
It's
May
already been
29th.
provided.
They say it hasn't. You
So
haven't
they would
put
have to
anything
prove that.
in
It can't just be
writing.
their word.
Okay, Mr. Brooks, we're going to reset this to May 29th, 2025 at 8:30 a.m. You will need to be present on that date and at that time. If you're not, a default order can be entered against you, okay?
Whatever, man. It doesn't make sense. Like they have whatever, man.
Any questions, ma'am?
I just want exactly what Attorney General is asking for the documents to be provided as far
That's
as.
something they will have to tell you, ma'am. Okay?
Yes, ma'am. That's all that I had.
Okay. Any questions from you at this point, Mr. Brooks? Not a statement, any questions?
I understand that, and I think I asked you that last time. Like you can just ask the question because I don't like the condescension. So this is my thing. I would like to request a written copy of this proceedings here. I don't know if we actually got on the docket, but we were sworn in, so it should be written. I would like to request that within the next 72 hours.
You can request a transcript of the court reporter, but you have to pay for it, sir.
That's fine. I'll fill out the form and have it waived.
All right.
Yeah.
Anything further?
Are we good to go?
Yes, if there's
Can I-
nothing further, you're both free to, excuse me, ma'am?
Can I ask you a question, Judge?
Yes, ma'am.
As far as the resetting for May 29th, we'll get the time and things in the mail like usual.
That will come from the Attorney General's office, yes, ma'am.
Okay, and on that, we're asking to request for documents as far as his.
You would have to ask the Attorney General what they're requesting. Okay?
Okay.
All right.
Okay, because like you said, or like it's been on document, it's been the third time. So I'm definitely open to making sure that we get everything we needed for the case. And I appreciate you seeing the case today. Thank
Okay.
you.
Anything further?
No, ma'am.
Anything further, Mr. Brooks?
It's not going to be taken into consideration, so that's fine.
Okay, sir. It's your
They
choice.
have everything. Otherwise, we wouldn't be here.
Thank you both for appearing here today, and you're both free to go.
Thank you.
The whole truth and nothing but the truth.
Yes.
Mr.
Yes.
Brooks?
Yes.
Okay. Ms. Sweet, I believe we were here in this case previously. After further review of the file, I found that Mr. Brooks was asking for some changes in conservatorship, and that's why I asked you to call them and have this set today. Mr. Brooks, am I correct in my review showing that you were asking for some changes in conservatorship?
Yes, there was conservatorship and other things that I've mentioned to the court in our previous proceedings, but yes.
Okay, so the conservatorship issues had not been brought to my attention. When I read it the first time, it says conservatorship is not an issue. That's what was checked. But then I read further in that paragraph and it says you were asking for some changes in conservatorship. Ms. Brooks, I'm not sure what your position is on this, but given that he's asking for changes in the conservatorship, I am inclined to refer this to district court. It's not going to make this case final. It just means that it will go to district court for continuation in this case, and any decisions will be made by the district court judge. Miss,
Go ahead.
Go ahead, Ms. Brooks. I'm sorry.
Am I able to give you testimony on that?
You can give me, not testimony, you can just give me what your position is on that. You can't tell me about what the conservatorship issues are or anything of that nature. Just tell me what your position is on, because this is not an evidentiary hearing.
Okay. My position on the change of the conservatorship is I don't understand why that would, I feel like he's trying to change the conservatorship to try to pay less money for child support because they have not had any contact with each other whatsoever in the last 5 years.
Okay.
Okay, in person. He has not seen my child in 5 years. He has not attempted to see my child in 5 years. And now, even with the last
your position, I just need to know your position on referring it to district court. You're giving me evidence now about what would go on in an evidentiary hearing for the conservatorship. Okay.
My position on that is that I think that we should continue to move forward the way we have been, asking for him providing the paperwork as far as his income tax and all that.
He will still have to provide the paperwork. It just won't be heard in this court. It'll be heard in a different court. That's all. It doesn't mean he doesn't have to do those things.
I'm against the change.
Okay.
Yes, ma'am.
Yes, ma'am. I understand. Ms. Sweet, the state's position.
The state sees no reason, Your Honor, for it to be referred to the district court. I'm not sure that conservatorship, it appears that both boxes were checked. And then considering what Mother had to say regarding the issue and, you know, our past 2 temporary orders that that was never brought to the state's attention or the court's attention. It was merely the support issues. But we'll defer to the court, Your Honor.
Okay.
We have the transcripts. The first transcript with the male judge, I can't remember his name, with Justin Dale, it was brought to you guys. And then I mentioned filing a formal complaint against the clerks because they didn't put it on the docket like I was told. I have both telephonic evidence as well as email evidence in writing. We came back subsequently. I brought it to yourself. I spoke of all 3 issues. So for the state to say it wasn't brought to their attention, I even mentioned it to her, Ms. Sweet, when I spoke with her in the breakout room because she was now on the case and not Justin Dale anymore. So to say that it wasn't brought to the court is false because when I initially filed with the district court at first, and then for whatever reason, they moved it over to the Title IV court, which there shouldn't have been a reason because, again, we had a private order with the district court, so it should never came to Title IV court. So the state has had it, and it's been brought up in all 3 hearings.
Okay, Mr. Brooks, first of all, just because you file it with the district court and just because you have a private order does not mean it can't come to to 4D court. Okay, there are lots of reasons and lots of avenues for something to get in 4D court. Second, the first time it was brought to my attention was when I went back and reviewed the file again. Now, you might have brought it to the district court's attention. You might have brought it to, you say, the male judge that was here when you first came. That might be true, but I didn't see it. Your case, Mr. Brooks, I'm still talking, okay? And so your child support has been reduced to minimum wage. You have not been harmed in any way by us resetting this. And I can refer it to district, but it's not going to finalize this case until you get to district. And I don't have a problem referring it to district if you actually have conservatorship issues that you want addressed. So, Mr. Brooks, because in your pleading, at first it says you don't have any conservatorship issues, and then it goes on to list some issues that are under conservatorship. So I'm asking you now, do you have conservatorship issues that you want addressed by the court?
Yes, I know
Okay.
exactly what I.
Then, Ms. Sweet, I am going to refer this to the district court. And Mr. Brooks, Ms. Sweet, will you get a setting for them, or will it be incumbent upon Mr. Brooks to get the setting in district?
Your Honor, if Mr. Brooks wants a temporary orders hearing, he would have to get that set, but we will get a pre-trial setting if nothing's been set within, let's say, a month. If he's not said anything, then we'll just go ahead and get a pre-trial if that's
Okay.
or maybe two to 3 weeks, Your Honor.
Mr. Brooks, did you understand what Ms. Sweet was saying? She was saying if you want a temporary orders hearing in district, you will have to get it set. If not, they will get a pretrial hearing set. Okay?
Yeah, I can reach out to the court. The temporary
Excuse
that
me.
was listed in the motion is moot. That was because I was on unemployment. You guys were taking 65% of the unemployment. So that's where the harm came from. That's in the motion, because the amount that the unemployment was, the child support was set at when I filed to have it reduced for a downward deviation, it was 61% of what I was getting in unemployment. And that's what I mean about, that's where the temporary came in, because you guys pushed the case out to September, which didn't make sense because you're saying it takes 6 months to get it heard when it's injuring me, but now we've had 4 hearings now in that time. So that was my point. So she keeps trying to push the notion that I'm requesting a temporary hearing based off something that was for 6 months ago, when it's more than that. But I'll work again with the district courts to file the things that I need to file for it when it moves to the district court.
Okay, so this case will be referred to district court. All proceedings will continue in the district court. And if there are no, do either one of you have any questions?
So, I mean, if you might can't answer it, she keeps pushing this false narrative for family violence. So she illegally obtained a protective order. We don't have to get into the semantics of all that. I wasn't even in the country. That's been thrown out in every hearing. So I don't want to keep having to go through the process of having that thrown out, because that was quashed less than a month, I believe, after she filed it.
Hold on 1 second, Mr. Brooks, let me just stop you right there. None of that has been before me. So I doubt if I'm going to be able to answer any questions on a protective order or when it was thrown out or anything of that nature, because none of those proceedings have been before me, and I'm not sure what the status of any of that is, okay? So that would be something you probably take up with the district court, all right?
Yep.
Okay. Anything further from anyone?
No.
Okay. Then thank you both for appearing here this morning, and you're both free to go.
Thank you.
Mm-hmm.